Good morning to everyone today, uh, or I should say good afternoon. I'm remote to everyone at today's public hearing of Panel A of the Prosecutor Vetting Commission. My name is Christopher Lehman, Chairperson of the Commission, and I declare this session to be open. The Prosecutor Vetting Commission is established under Law Number 252 on the external evaluation of judges and prosecutors. Law number 252 establishes that this commission will undertake an ethical and financial evaluation of prosecutors who are identified under Article 3, Paragraph 1 of that law as subjects of the evaluation. This three-member panel is constituted to conduct that evaluation pursuant to Article 15 of Law number 252. This hearing is being conducted pursuant to the provisions of Article 16 of that law, as well as the Commission's rules of procedure for evaluations under Law number 252. The subject of today's hearing is Nicolae Mătăsaru, a prosecutor in the Anti-Corruption Prosecutor's Office. Mr. Mătăsaru, welcome to the proceedings. I'm joined today by my colleagues on this panel, Nadezhda Hryptievsky and Herman van Hebel. The panel is also assisted by members of our Secretariat. The first part of this hearing will be open to the public and members of the media. The second part of the hearing will be conducted in a closed session in order to protect the privacy and confidentiality of concerned third parties. The hearing will be conducted with interpretation into both Romanian and English, and I will ask everyone that in order to allow for accurate interpretation, people should speak slowly and clearly. The proceedings are being recorded. The recordings of the public hearing will be available online on the Commission's website within 3 days after the hearing. During this hearing, one or more members of the panel may ask questions to you. I would ask that you answer them truthfully and completely. Your explanations are important to us in verifying your compliance with the criteria for financial and ethical integrity. In formulating our questions, we will take into account your privacy and, where required and possible, privacy of your family members and close persons. To that end, we will leave out unnecessary details relating to ID numbers, bank accounts, specific addresses of real estate, and the like. And for your protection and privacy, we would suggest that you do the same. You will be given an opportunity to make a closing statement to the panel at the end of the hearing. Let me start by briefly reviewing the evaluation process for this subject. The Commission initiated this evaluation process on the 24th of May 2024 by notifying the subject by email and asking him to complete and return both an ethics questionnaire and a financial declaration form. This is required under Law number 252. The subject returned the completed questionnaire and the declarations on the 12th of June 2024. As part of the evaluation of the subject's ethical and financial integrity, the Commission also obtained information from many other sources, such as the National Integrity Authority, the State Fiscal Service, the General Inspectorate of the Border Police, other public institutions, financial institutions, and open sources. The Commission assesses the information it obtains from these sources for its relevance and reliability. The Commission also sent you 4 rounds of questions. Those were on the 23rd of October 2025, the 12th of December of 2025, the 5th of February 2026, and the 13th of March of 2026, to which you responded. On the 16th of April 2026, this panel further advised the subject that the panel, after the analysis of the accumulated information, did have certain doubts to discuss with you. These doubts were detailed in an annex to the hearing notice that was sent to you. You requested to change the date of this hearing, which was accepted by the panel. On the 17th of April, you submitted a request for a partially closed hearing. That was also accepted by the panel on the 21st of April 2026. Today's hearing will be conducted accordingly. As I noted, the first part will be an open session, and then we'll move into a closed session. Mr. Mătăsaru, the panel also received your statement on the notice of hearing, as well as several attachments that you submitted yesterday on the 27th of April. Please note that the panel will analyze this information after the hearing, since it was submitted only shortly before today's hearing. Today's hearing will be conducted within the issues identified in the notice of hearing. However, if you wish to refer to information you submitted yesterday, please feel free to do so. Thank you again for appearing. I'll begin by asking two short questions. I'd ask you to respond to those in a complete and truthful manner. First is whether you need to make any additions or corrections to information and answers that you've previously provided to this commission.
Chairperson, esteemed members of the panel, everything I declared in the ethics questionnaire and in the declaration, all of that is still valid and current, with all the additions that I provided to the Commission during the entire evaluation process.
Thank you. That answers my second question. So at this point, I will give the floor to my colleague, Nadezhda Hryptievsky, who will proceed with some additional questions for you regarding the doubts that were raised in the hearing notice.
Thank you, Chairman. Bună ziua, domnule Mătăsaru.
Hello, Mr. Mătăsaru. A religious greeting about Christ having resurrected. So I will be talking Romanian. You will not need the headphones. In the public part of the hearing, we will discuss questions about the difference that the panel found in a total amount of 763,214 lei during 4 years out of the evaluated period. And for clarity, we will discuss every year in particular. With respect to your inexplicable wealth found by the panel for the year 2012 in a total amount of 189,603 lei. The first question is about your cash savings. You declared as 200,000 lei at the beginning of 2012, out of which 50,000 were set by you and 150,000 you received as a donation from your parents. Is that correct? Yes, it is correct. Please explain in what context did you receive that donation? Could you please provide more details? Yes, thank you for your question. First of all, I would like to make an introduction to the evaluation process of me as a subject of evaluation under Law 252 of 2023 on the external evaluation of judges and prosecutors. As a result of a detailed analysis of doubts and arguments underlying those doubts, today, before the panel, I would like to express my disagreement with the preliminary conclusions of the panel, as they were phrased, about the existence of inexplicable wealth for the year 2012, 2014, 2015, and 2016, because they rely on an incomplete and inconsistent analysis of the facts. This is because in an unjustified matter, relevant evidence was rejected, and a differentiated and disproportionate evidentiary principle was applied. Mr. Mătăsaru, please, let's proceed as we usually do. The panel prepared some questions, and that's why they are called preliminary doubts. We have some questions to clarify those doubts, and if we don't cover all of the issues that you raise, at the end you will have the possibility for every sub-questions to add what you need to. Will that work? Because we have some things that we want to hear answers about. Okay, thank you. So the first question was about the following. Can you explain the context of a donation you received from your parents in 2011 in an amount of 150,000 lei? Sorry, I can't hear. Then later I will speak about all aspects mentioned in the hearing notice. Now I'm only answering your questions. Yes, answer our questions, and then everything we don't cover, you will be able to approach with your additions. One essential aspect that influences directly and significantly the incoming financial flows of my family for the year 2012, as you formulated that, is not including into the table the income obtained from the donation received at the end of 2011 from my parents in an amount of 150,000 lei, as I declared in the answer to the first question round. It was round 1, question 1, and then round 2, question 2. In this context, I believe it is relevant that from the very beginning I mentioned that donation. I explained the sources of income of my parents without knowing if in the end the panel was going to have any doubts or not about the income of my family. I think this is important to mention. At the same time, in this context, I express my disagreement with the fact that the panel did not accept the amount of 150,000 lei because of a lack of confirming documentation explaining my parents' financial capacity for such a capacity, because, in my opinion, the information and evidence provided previously to the Commission show with certainty that my parents had the financial capacity to give my family such support. Sorry, Mr. Mătăsaru, you filed a request to the panel to discuss the sources of your parents in a closed hearing. Do you want to discuss it in an open hearing now? The general aspect, I think we can discuss in an open hearing, and then because we accepted your request to talk in a closed hearing, that's why I want to make it clear. Do you want to discuss it now? My question was, can you explain the context of the donation? When did they offer it to you? Why did they offer that money to you? As I mentioned in the previous question round, this money was donated by my parents at the end of 2011, when I, together with my family, became owners of a real estate that was much expected by our family. Given that our family consisted of 2 grown-ups and 2 children, we were all living in a one-room apartment, 4 people, several years in a row. That event was something much awaited by us, and it was an achievement for us. And in that context, my parents decided to donate us that amount of money that was obtained from legal work for a period of more than 35 years of official employment, but also from additional informal activities, as I explained in detail: farming work, holding land plots, gardens, vineyard or wine plantation, cattle, and so on. That was also generating income for my parents' family. This donation was made to my family, as you have noticed from all of the provided materials, only one time. That donation took place at the moment when my family truly needed it. Initially, that donation was meant for us to be able to start renovation works in the summer of the next year. Initially. Subsequently, though, the money was used for another purpose that I mentioned in the question rounds. So, to a large extent, the donation of the income supporting the donation was obtained from the official and unofficial employment of my parents, as well as my mother's activity for several years based on an entrepreneurial patent. Yeah, so you received the donation at the end of 2011 to do repairs, renovation works in half a year's time? Yes. Usually, renovation works start in summertime. And again, if the people, the workers, so you have bought the apartment by that time? Yeah, the apartment by that time was registered with the cadastre. It was purchased in the previous year, but in November 2011, if I'm not mistaken, we registered the ownership right. And the donation took place in November, immediately after registration. The donation took place at the end of the year for Christmas holidays or New Year's, if I remember correctly. It was at the end of 2011. So the entire amount was donated to you in cash? Yes, the entire amount in cash, an amount of 150,000 lei. So you did not declare this amount in your annual declaration for the year 2011. You provided your reasoning. We would appreciate it if you could still explain that now. Why didn't you? Only because of a lack of a separate column there, or for other reasons? When it comes to panel's statement in paragraph 15 in the hearing notice that the donation in the amount of 150,000 lei is not supported by confirming documentation, and the panel made reference to two aspects, donation agreement and presence in the annual declaration. I will speak about both of them as they relate to the same topic. So with respect to the Commission statement that there was no agreement regarding the donation or other proof, and that I did not declare the donation in the declaration for the year 2011, I would like to say that in line with provision of Article 208, paragraph 1 and 2 of the Civil Code, valid in 2011 when the donation took place, any legal act could have been concluded both verbally, in writing, and in an authentic way. In this situation, to continue my ideas, according to the Article 209, paragraph 1 of the same code, the legal act for which the law does not prescribe a specific form can be concluded verbally, and that is what we did. That is one of the reasons. The second reason is that this donation was made by my parents. Obviously, I trusted them, and they trusted me and my family, and obviously, there could not be any legal consequences like challenging it or other similar matters. In the context of the aforementioned legal provisions, I believe that concluding a written agreement between me and my parents was not mandatory, because the object of the donation was not a good for which sale a specific contract form was required, because the object of the donation was money. Moreover, according to Article 830, paragraph 2 of the same code, valid at the time of that operation, not following the form does not affect the validity of a donation if the promise is fulfilled, except for contracts that have as an object goods for the sale of which an authentic form is required. Consequently, in my opinion, the first argument of the Commission that there was no donation agreement is not plausible in the described situation, because it was not reasoned according to the law. When it comes to not mentioning that amount in the 2011 declaration, I explained in details in the question rounds and in my written statement, and I will share today a few of the aspects that I believe are relevant. I would like to mention that in the period of 2011 to 2015, the National Integrity Commission, the only authority from Moldova that was responsible to check declarations of assets, was not operational. That's the first thing. And I mentioned in my written statement concretely decisions of the Parliament whereby the members of the Commission was approved, and they are before the end of 2012. At the same time, when it comes to financing and operation of that commission, I would like to mention that only starting in 2013 that did take place, saying that the existing legal framework at that time was deficient and ambiguous, and that was found in several studies. I mentioned which concrete studies they were and when, in which years they were carried out. One of them was carried out in the end of 2014. In this context, I believe it is important and relevant to mention that only in 2018, by Order number 15 of 27th of February 2018, the regulation on how to fill out declarations of assets and personal interests are to be filled out. So, therefore, in this period, and I specifically mean the year 2011 as well as the subsequent years, because I believe those years will be discussed during the hearing, there was no legal framework allowing the declarants, people in public office, judges and the prosecutors, to consult or to ask for some information from the competent authority responsible for that field. Also, in the written statement that I provided to the panel that you received, I explained in detail the relevant legal amendments, namely, I want to refer to the template of the declaration that was filled by me, among others. According to the legal provisions that were valid at that time, in the template of the Declaration of Assets and Personal Interests, there was no section, concrete section, where donations were to be declared. This was improved by legal amendments by Law 181 of 2011, published in the Official Gazette on 6th of January 2012, which came into force on the 1st of March 2012 after filing the declaration for 2011, which I filed on the 30th of January 2011, if I remember correctly. Both the legal framework on concluding donation agreements and the lack of a legal framework, lack of a concrete legal framework explaining or approving a template showing the donation specifically did not exist at that time. These are the reasons why I did not mention the donation in the declaration for 2011. Thank you, Mr. Mătăsaru. We will discuss the financing source for this donation in more detail, but if possible, if you believe it is a detail that may affect the private life, privacy of your close people, you may decide not to answer, but if you want, you can answer. Did your parents make similar donations to your other siblings? Not to give details. Or was this a donation only to you, the only one? Yes, they made similar ones. First of all, to my younger brother. From what I know, from what I found in the evaluation materials, they donated some land plots to him, farming land, that my father obtained from my grandmother, and then they donated the land plots to the younger brother. Secondly, the younger brother does not need such donations because the income that he has allows him to be economically independent. It's just the other way around. Over the last years, when my father was still alive and now with only my mother left, he helps them regularly with money in some situations. That is about my younger brother. About my older brother, he has left the country for more than 30 years ago. He lives with his family in a country which is not relevant, and certain money amounts were transferred to him occasionally, as I informed the Commission. When my parents decided to transfer certain amounts, if needed, we can discuss about specific amounts in a closed hearing. That's why I believe this approach of my parents was decided by them. But the most important aspect, I think, and that I talked about, is that I and my wife are the only ones in our families who stayed in the country and continue to help them since we are married for the last 20 years, more than 20 years. This is another plausible reason, argument, I believe. Thank you. The panel for the year 2012 did not accept, just not to repeat it for every year, that is also valid for 2014 and 2015. In your communication with the Commission, you mentioned that grandparents were making gifts around 10,000 lei for each child. And in the period 2012 to 2015, the legal framework was very clear about donations, and the panel did not accept it because these amounts were never declared to NIA. And you, from what I understand, you disagree with this approach. Do you want to comment on it? Yes, esteemed Commission members, I want to comment on that. I admitted that I omitted to declare these symbolic gifts made by grandparents for the only grandchildren that are in the country on the occasion of certain important holidays, birthday, New Year's, Easter, and so on. But for the first time, I declared this symbolic help in the year 2016. But I would like to mention that these symbolic gifts took place, and before that as well. I don't believe there is any rationale for grandparents to make such gifts in 1 year only. Yes, I admitted that omission by not declaring those amounts, but these symbolic gifts were made every year, which I believe is normal. Mr. Mătăsaru, but these gifts made by grandparents to children, to grandchildren, to buy, probably for them to buy some current things, I don't know, a game, a bicycle or something, do they influence in a determinant way the financial condition of your situation, and excluding this amount has a crucial impact on your financial condition? I think it does not influence it essentially, but in my opinion, it is correct for the Commission to establish whether these gifts were made or not in reality. And I state with all my certainty that all these donations were being made every year, and if you look at them in relation to other income, it influences to some extent, but not significantly. You also disagreed with the way that the panel included cash savings into the financial flows. The panel explained this methodology in the hearing notice. It is mentioned in all of our reports. There's jurisprudence of the European Court that specifies how it is qualified. Do you want to say anything about that now? Yes. I would like to discuss more concretely about some things that I believe are important, and namely the formula used by the Commission in my specific case is disadvantages from the very beginning.
As regards the calculation of income and expenses for 2012, I must say that according to the general accounting rules for an annual balance, the savings at the end of the year, cash savings and bank savings, since these terms are used, they cannot be included in the outgoing flow in the column for expenses. These are part of the final balance of cash, and that is the result of the differences between all inflowing money and outgoing ones. So in this context, I must mention that savings on December 31st, they become the opening balance on January 1st of the new tax year. Out of this reasoning, or the basis of this reasoning, the savings at the end of the year cannot be regarded as income for the next year. They cannot be reported in the income column, but they represent the opening balance at the beginning of the year. The savings at the end of the year represent the funds accumulated during the year that have been spent for consumption during the year, so they cannot be part of the outgoing flow. The savings that exist at the end of the tax year cannot be regarded as expenses because they do not represent amounts that were incurred in the meaning of the tax law, but that is money available, that is left over, and that is carried over into the next tax year, into the beginning of the next year. Mr. Mătăsaru, we have all of this information. Maybe we managed to clarify because we have this. You are stating that at the end of the year you had in cash, say 10,000 lei. We calculate that as expenses because they are there. You haven't spent it out of all the income that we calculated. You say that you are left with 10,000. And it is specifically that amount that is at the end of the year that we regard as income in the beginning of next year. We did not come up with this methodology. It is a well-established methodology and used also by the case law, as we can see in the case law of the European Court of Human Rights. What is it that you are challenging? Because it's really not clear the way you're putting it. So this is an expense for the previous year. But that exact amount also comes into the next year as income, because you've stated that this is how much you've saved last year. So where actually is the problem, and what is unfair about this procedure as you claim, as far as you are concerned? Thank you. I've also looked into the practice of the European Court in this regard, Sokaj versus Albania, and specifically I've looked into how savings were being tackled, savings out of considering the expenses that have been incurred during a year of the reporting year. So over there, what is mentioned is the relevance of the carryover of funds from one year to another. That is the savings, the closing balance, and the opening balance. The savings, by no means can they be regarded as expenses, because at year end they exist. And that is with regards to the modality of calculation. That is a surplus of cash, and that is the difference between income and expenses incurred during the year, the reporting year. In this particular case, what is relevant is the constant practice of the National Integrity Authority, the only authority in Moldova that is responsible for carrying out controls or verifications into violations of legal provisions regarding assets and personal interests, that during controls looking into assets and personal assets when they carry personal interests when they carry out when they make calculations to establish the difference between income and expenses. The savings at the end of the year represent the closing balance, and that is not reflected in the expenses incurred during the reporting year. Concurrently, though, those savings, they represent an opening balance at the beginning of the next year, and they are not additionally included in the income column. You're using different terminology, understood. Can we move on to the next question? Yes, if you think that that is required. You've also stated that you've sought, but we want to ask why. Well, why is it that you disagree with the amount that the panel has come up with for the CEP? You've stated that that has to be smaller, that has to be diminished. The panel stated that there aren't enough reasons for that reduction, but you continue to disagree with the amount for the CEP for your family? So the CEPs that you mean, understood. According to the NBS, yes, according to the NBS. In fact, as regards the CEP, I would like to address this thoroughly as regards the way the panel has taken it into account to make calculations regarding my family for these 4 years and my parents' household. I have provided in detail an explanation of that. However, as regards my household, I believe that the CEP need to be diminished for my family, and I have also provided the reasoning for that. Could you explain the gist of that? That is, what is specific, what is peculiar about your lifestyle or the lifestyle of your household to be persuasive enough, convincing enough, so that so as for the panel to diminish those expenses. Those expenses were not established by the panel, but on the basis of analyses carried out by the NBS for an average family in Moldova. It's an average one, an average household. The Supreme Court of Justice explained very clearly, if the subject disagrees, the subject must provide convincing, persuasive proof. So what is so peculiar about the lifestyle of your household that would be a good reason for such reduction? Could you say what are the categories of expenses that you think should be subtracted or diminished? Thank you. First of all, I would like to say that the expenses as per and for the CEP, as put down on the website of the NBS, they are general and just indicative, and they can be used if there is no other concrete data. This is my opinion. So this is why I believe they cannot be fully used for the financial situation of my family or of the family of my parents. This matter, though it doesn't have a meaningful, significant impact on the closing balance at the end of 2012, but that has to be taken into account by the panel. Well, that is the negative balance of 7,833 lei that came out of the CEP of 74,000, and that compared against the net income of my family, 66,807 lei. In this regard, I believe that keeping CEP at that full extent for my household is unreasonable. And that is because the actual income of my household was smaller, well, that was smaller than the statistical standard used by the panel, and diminishing the CEP in such a situation is a recognized practice confirmed by the case law of national courts. In the detailed situation, what is required is to look at the case law of the Supreme Court of Justice. There is a final decision of the court of the 16th of August 2024 regarding Rodica Kirtok versus the Superior Council of Magistracy, and that with regards to the law number 65. The Supreme Court of Justice has established the unreasonableness of using the CEP of this statistical threshold for the assessment of magistrates and prosecutors because of the legal limitations of the income sources and their workload, and that presumptively excludes obtaining additional income. In this regard, to force the person subject to the evaluation, myself in this case, to argue income that does not cover the theoretical expenses of consumption, the CEP that is, given there are legal restraints as to income and given the justified impossibility of contribution from the partner, that is a disproportionate burden of proof. So, as long as my family, my household had some income, myself and my wife, we had income below the CEP established by a general formula by the NBS, I believe thus that it cannot be fully applied, entirely applied. That is one aspect. The difference isn't that big, but still it's 7,833 lei. Excuse me, but for your wife, did she work in the public system as well? Well, she was in a number of activities that I've already mentioned in my correspondence with the Commission in greater detail. I shall continue in the same train of thought with regards to the CEP. I believe that in the rounds of questions and answers, I provided thorough answers explaining that both my parents and the parents of my wife owned some farmland around the house, adjacent to the house, and some farmland that allows them to harvest different crops and grains and to raise some poultry, some livestock, which is confirmed by the documentation supplied to the Commission earlier. Additionally, as a pertinent piece of proof supporting my statements, I've also annexed in the correspondence with the Commission certificate number 88 of 2026 issued by the mayor's office from the village of my parents-in-law that I've obtained after the hearing notice that confirms that my parents-in-law indeed have had livestock in their household and they've used them for their own consumption as well as to provide for my household as well. So, since 2005, since I got married, and to this day, both my parents and the parents of my wife have been permanently supporting us by giving us foodstuffs, poultry, beef, fruits and vegetables, eggs, and we've been using that in our day-to-day life. And therefore, the CEP expenses cannot be established, cannot be based on or used on the basis of some general parameters of the NBS. But the foodstuffs, as per that formula, they represent about, on average, 45% of the total expenses as per the CEP. And in this case, that is not applicable, that cannot be entirely applied, and this parameter has to be partially diminished on the basis of the reasons that I've just explained. Similarly, considering the formula used for the CEP-based expenses, so out of that what has to be subtracted is the expenses for tobacco, restaurants, hotels. My family in 2012 has not used such services or has not purchased such products. So, as regards to CEP, what should also be subtracted is the healthcare expenses. Annually, that's about 8–10%. But in that period that is subject to assessment, and specifically 2012, all my family members had health insurance being hired and having been employed, and the children were subject to free of charge health services. In conclusion, considering the aforementioned, I believe that in my particular case, and for 2012, the CEP for my family should be diminished by at least 15%, and this would ensure fair and accurate calculation of this amount. To support this context, I've also provided in the annex, I've supplied pictures, supporting documentation, deeds of ownership, and as the need may be or as may be required, I'm not sure there are other documents, but I think that all of the documents that I've made available are indicative of the fact that there is at least one legal ground for the family, for my household's expenses not to be calculated as per the maximum values, parameters of the NBS. Thank you very much. Now for 2012, is there anything else you could add, or can we move on to the year 2014? There are a few other matters that I've additionally supplied that the Commission was not aware of until the hearing notice. And that too needs to be included in income, and I provided supporting documentation in that regard. And there are some other expenses that are also not that relevant, not very relevant, but required to be taken into account nevertheless for the final calculations by the panel. Do you mean what you filed in writing? Yes, well, that we will certainly analyze with due attention. Now let's then move on to the year 2014. And the difference that we have established preliminarily is 44,400 lei and 405 lei. Let's not go over again over that discussion regarding the 10,000 donation. I mean, that is valid and true for all of these years from 2012 through 2015. But in the hearing notice, there was a piece of information that was novel, and that is something that I would like to underscore that has to do with the holiday, the vacation expenses of 40,091 lei. The Commission has identified that as such and included them into the calculation. Is there anything you would like to comment with regards to that amount? Yes, thank you for the question. I did see that those expenses were included. There was limited time for me to look thoroughly into all of the materials, but out of what I've managed to see in the evaluation file as regards this vacation, there is only one table without a contract on the provision of tourism services, without a receipt, without having a receipt that would confirm that this amount was collected from me. Well, without even in the absence of that, I do not refute, do not deny, do not exclude certain expenses. Now, as regards their inclusion in the table, we've gotten this information from the travel agency. If you deny that, we can double check, but this information has arrived to us from the travel agency. Understood. For 2014, is there anything else you'd like to add, or can we move on to the year 2015? I think we can move on to 2015 because for all the savings, for all the years, I will make a general statement that'll be true for all the years. For 2015, the difference that the panel has preliminarily established amounts to 220,549 lei. Now, my first question is with regards to the donation that you've reported amounting to 2,000 Swiss francs. That is 39,140 lei received from your brother. And in the answers to the panel, you've stated that that was support for your family, and that was a sort of a thank you. Can you explain what was that thank you about? Well, that amount that I've stated of 2,000 Swiss francs, that was made by my brother, a donation from my brother. For a while, quite a long time, he's been living and working in a European country. I don't think I have to now even mention what country that is. So that donation was made by my brother. That was support for the support that my family provided to him until he left abroad, until 2012, for as long as he has lived and worked in Chisinau. He would often come over to see us, to us, and he was actually, we were helping him out. Afterwards, as he has had this financial possibility at his initiative, he donated that amount, that insignificant amount, in his opinion, that was insignificant amount donated by him to my family. And what currency was that in? Right now, I don't remember precisely. Perhaps it was Swiss francs, because from the moment that he left abroad every time he returned back to Moldova, and that would happen about 3 or 4 times a year consistently, and that is still the case to this day, and the Commission is aware of it because nothing has changed in this regard. Every time he'd come, he'd bring about some savings he would manage to put aside, and then as for how he was keeping that money, I will state that in the closed session because I don't want to go into those details now. But you specifically received that in cash. Yes, in cash. And you kept it. Yes, I did. So it is my understanding that he was on vacation, or why was it that he has come at that time to Moldova? It was not necessarily a vacation, but when he can, when work allows for it, when he has some time to spare, especially when both parents were alive, he would regularly come back to Moldova, not a vacation necessarily, but just on a visit to see our parents, to see us, an ordinary thing. And that was the first donation from your brother to you, the first financial donation. Is that correct? Yes, the first donation. And speaking of the support, he was provided until 2012. Why was it in 2015 that he made the donation to you? Well, he made that decision at that time. That's when he was able to afford it. He was getting a particular income. He had already become, getting integrated with the country. He had a stable job, and he had the possibility to afford such a donation, which was not significant in his opinion. And until then, until the donation was made, he did not have a stable job. Well, yes, he did. But from the very beginning, as I told the Commission, since 2012 onwards, he has permanently been staying there. There's a Swiss family, and I've already provided that statement of the person concerned, and that is his second family. He's been living there for a long time. He still is staying there. And in fact, he is like a child for that family, because, and all the more so since the statement, whose statement is in the case file, when they need something, my brother is there to provide all the support that they need, even to this day, regardless or no matter what. Understood. If there's anything else you'd like to add regarding this donation, you may do some. Otherwise, there's another donation I would like to ask you about. As regards this donation, I would only like to mention that, this has occurred in 2015, a few years. My brother was already staying in the country for a few years now, and he was earning his own income. What is more, according to the information in the evaluation file that was made available to me by the Commission, from 2012 to 2013, so over these years, my brother has received bank transfers from particular people amounting to more than 2,000 euros and about $1,900. Even without other income, my brother had the actual genuine possibility to provide that support to me. Not to mention that for as long as he has stayed there to this day, my brother doesn't incur expenses for a place to stay, foodstuffs to support himself. And that is confirmed by a Swiss national who has a particular degree of responsibility when it comes to the legal and financial fields. And what is more, that person does not even know me personally and has no reason to make fake statements, false statements. So it is upon their own accountability, subject to liability, so to speak, that they've stated that it was their own responsibility behind telling the story that they did about my brother. So for that donation, transfers from 2012 and 2013, they are confirmed, supported by banking information, not just mere statements. So my brother had the availability, he afforded this support to us. Well, as you've requested and as we've accepted, the brothers' sources of financing will be discussed in a closed hearing. So we do have some questions regarding this, but they're going to be asked in a separate part. In the 2015 declaration, you've also declared a donation from your mother-in-law of 9,000 euros, that is about 188,000 lei. Could you please explain what was the purpose of this donation? I confirm now in front of the panel that that donation was given to us by my mother-in-law in 2015. Actually, that was a consistent support from the parents of my wife, intended for us to perform most of the refurbishment works in the apartment MB, as mentioned earlier. So you can just say, is it the first or the second? For the second apartment where my family was supposed to move into. Excuse me, but is this an apartment, a different apartment than the one that the donation was made for by the parents? No, it's the same apartment. And in fact, it is the first strong donation from my parents that was again as a form of helping out, given that until 2014, I and my family, we've stayed, the four of us, in one single room. Just to clarify, you mentioned earlier that in 2012 you've performed renovations on the basis of donations from parents of 150,000 lei, but now in 2015, the 9,000 euros donation, was it for renovations and refurbishments in that same apartment? Well, the same apartment, but about parents' donation, they were not used for refurbishments. And that I already communicated in the written correspondence with the Commission. That donation was given to be able to, for us to be able to initiate renovation works. However, given that at that time, I had taken a bank loan, and thus most of the payments were being made to pay out the interest, not the actual body of the loan. By agreement with my parents, the parents agreed. In fact, they were the ones who insisted on it. They stated that it is best for us to pay up that loan with the funds that they gave us, because there was no point in paying out of 2,000 lei, 1,600 was interest and 400 lei was the actual loan. And my parents, they were older and wiser. They thought that it makes sense to do it like that. So that was their initiative, to pay up the loan and to have the family, the entire family, 2 adults and 2 children, the four people, to live there until the end of 2014. And in 2014, we've managed, using the savings that we had set aside, though not very big savings, we managed to only perform some work, some refurbishments, renovations in one of the bedrooms and in the kitchen partially to be able to move in, and then the works were being performed as we stayed there. In 2015, that's when a lot of works were performed. The parents of my wife helped us out in that regard. And who would you seek the support of when you need it? You turn to your parents and to your family, to your relatives. So between 2012 and 2014, the apartment did not sustain any refurbishments whatsoever, and you were living in the previous apartment. Yes, in December, at some point until the end of the year, the family lived, all of us, the 4 of us, in a one-bedroom apartment. So that donation, do you remember when the mother-in-law donated it to you? Was it winter, summer, on holidays, or just like that? As far as I can remember, I think it was at the beginning of the year, because we had already began performing some superficial works, some partial works in that apartment. And on the occasion of the Christmas holidays and New Year's, we always meet together and we discuss about future plans. And my mother-in-law said that she had funds out of the work that she has been doing and that she could donate that amount, obviously, in order for us to perform the renovation works and so as for the entire family, her grandchildren, move into a more spacious apartment. Our children were growing up and we needed more room. It's as simple as that. And a question similar regarding you. Now, your mother-in-law has she made similar donations to the brother of your wife? No, she didn't, because they did not have such a need. Both brothers of my wife have been living in the US for a few years now. They have houses that are worth hundreds of thousands of dollars. They don't need the support of the parents. All the more, actually, quite the contrary. When they come to Moldova once a year or every 2 years, every time they do, they help their parents, not the other way around. In 2015, they needn't any support, and the same is true for 2016. At that time already they were financially independent. One of the brothers at that time was already away and staying in the US, and he did not need any donation whatsoever. And the second brother was in the UK, and he was on his own, meaning he didn't have a family, so he did not need support from parents.
As I mentioned, it was about me or my wife, but one of the main reasons, one of the main aspects is the fact that it's only our children that are in the country for the period that we have been married. The grandparents have no other grandchildren in the country. It makes them happy when they can meet. I can't even explain what it means for grandparents. Thank you. Would you like to add anything else for 2015, or can we move to 2016 now? Only about the source of funds. That's in the closed hearing. Because we are talking, to make it clear, we're only saying that because you provided several reasons, including security reasons, the fact that that we are not public persons. That's why we'll discuss separately. Yeah, it was their request, actually. And since they can't ask for that, I did that on behalf of them. Tell me, please, for the year 2016, the panel established a preliminary negative balance of 308,657 lei. Similarly to 2015, in your annual declaration for 2016, declared a donation in amount of 5,000 Swiss francs. That is about 100,000 lei received from your brother. Please explain the reasons for that donation. Thank you. That year, 5,000 francs. That it was 2016. For 2016, received a donation from my brother and from my mother-in-law. And these donations also were made with their consent, at their initiative, in order for us to be able to complete the renovation works that we started long ago, back in 2014. To finish all of the renovation works. That was the ultimate purpose of the donations made in 2016, both the one from my brother and from my mother-in-law. So the works continued and were completed in 2016. Could you please explain in what currency this donation was offered to you and how did you keep it? This money was offered in the currency that was mentioned, in cash, both by my mother-in-law and by my brother, at the beginning of the year, for us to have the possibility to continue what we started in the year before. The same method that I described. Well, if you want to talk about that altogether, let's do it. But for clarity, we talk about 5,000 Swiss francs donated by your brother and $5,500 donated by your mother-in-law. Correct, that's it. Both amounts were donated for you to continue renovation. Yes, that was the purpose of those donations being made. Did the repair works cost around $20,000 euros? I provided detailed calculations to the Commission. 50-something thousand in 2014, approximately 200,000 in 2015, and 120,000 in 2016. But here I would like to make a comment. All these calculations are estimates based on the declarations I filed to NIA, and after those donations are taken into account. Another aspect which for me is not clear is the following. When we talk about income, the panel takes into account the minimum amount, but when we talk about expenses, the panel takes into account the maximum amount. So I believe this differentiated treatment for subject is not that clear. In some cases, the Commission, again, after asking the subject, took the average between the minimum and the maximum amounts. In this situation, when we talk about expenses, for every year the maximum amount was considered, and I did not understand why, because this is a differentiated approach within the same process with respect to the same subject. Mr. Mătăsaru, the income are taken into account according to the data. There is no minimum or not minimum, but it's based on what I declared. When I mentioned, do you mean your mother's income? We'll discuss that separately, or your income as well. Not only your income, not only my mother's income, that we'll discuss separately. That's something else. But your income is according to, not my income, not my income. Then what do you talk about? I don't understand. I mean, all these expenses that I mentioned, they were taken by the Commission, accepted by the Commission, according to my statement, in the maximum amount, even though I gave an estimate between the minimum amount and the maximum amount. I think it should have been an average that was taken, at least this is the treatment I expected. Both amounts were given to you in cash, yes. Let's discuss now about the car. The panel included in your outgoing flow for 2016 the purchase price for a vehicle, Mercedes, manufacture year 2010, in an amount of 200,000 lei. Starting 24th of August 2016, that vehicle is registered in the name of your brother. Since 16th of September 2016 and to this day, you and your close relatives have been using that vehicle. And 3 weeks after the purchase of the vehicle, you signed up for a vehicle insurance for the period 16th of September 2016 to 15th of September 2017. In your annual declarations for the period 2016 to 2023, you declared the right to use that vehicle. In the written communication with the panel, you declared that that vehicle is property de jure and de facto of your brother. It's just that you use it when your brother is not in Moldova. Explain us, please, why your brother purchased that car, since you state that it is his. In the communication with the Commission, I tried, and in my opinion, I provided documentation, confirming documents and declaration on own responsibility within the boundaries of what was possible. About the panel's position expressed in section 73, paragraph 73 of a hearing notice, and about including in the outgoing flow of 2016 the amount of 200,000 lei for the purchase of a Mercedes vehicle, E220, I would like to mention that I express my disagreement with this position because the panel itself claimed that it has only preliminary doubts about the beneficial ownership over that vehicle without any existing pertinent evidence that would show undoubtedly that I or my family incurred expenses for the purchase of a car in 2016. About the purchase and use of that asset, I talked thoroughly in the answer to question 37 of the first round and question 15 in the second round of questions. So, question 19, second round of questions. With respect to the mentioned vehicle, I declared and I continue to hold to that statement that based on what was communicated by my brother and based on the information that I have, this movable asset was purchased by him in August 2016 because, as it follows from his declarations, he intended to come back to Moldova after a period of around 4 or 5 years that he lived and worked in a European country where he earned certain income. And thinking of developing a business in the field of hospitality and international tourism, it was in the same year, 2016, that my brother purchased 2 real estate, and I told the Commission about that, and I provided relevant documentation to this end, that would be rented out in a hotel regime to tourists and guests of the Republic of Moldova. That vehicle was also going to be used by him for personal purposes and also to provide transportation services to guests and tourists. After some time, though, after he consulted other acquaintances and after making a thorough analysis of his intent for a short, medium, and long term, he gave up on this idea and went back to the European country. At the same time, in this regard, I believe that the declaration on own responsibility of the Swiss citizen that my brother provided, so I believe those statements are also relevant and they attached to the evaluation materials, where that person confirmed his intent to go back to the homeland to run a business, to purchase a car, and about the support that the mentioned person provided to him. Last but not least, I would like to say that my brother was the person who purchased and paid for the said car, and that is confirmed by his declaration on own responsibility of a seller of that asset, PI, which was attached to the given answer, and I provided it to the panel as additional evidence. Both the seller and the buyer, both of them, declared that that transaction took place between those 2 people. Also, the fact that my brother had the initial intent to purchase the vehicle for himself and he took direct part in the transaction is confirmed by his declaration, by seller's declarations, by the information about my brother personally paying on the 5th of August 2016 into the account of Registru state-owned enterprise all of the payments related to the registration of the asset in his name, in the total of 6 payments altogether, as well as payment of a road tax in an amount of 928.7 lei. That was confirmed by official banking documents, namely the answer of Moldinkom Bank, file number 122 of the evaluation file that was provided to me by the Commission at my request. At the same time, my brother, for that car, drafted the first third liability insurance valid between September 2015 and September 2017, while he and he was the main insured person. That was confirmed by information from the Platform M-Connect file number 206 of the evaluation folder that was provided to me by the evaluation at my request, provided to me by the Commission at my request. And additionally, that shows his initial intent to purchase and use that vehicle. I believe that all this data and information that the panel has, by analyzing that jointly with the declarations of my brother and of the declarations of the seller, point directly to the fact that the car was purchased by the former and all the documents were registered in his name. He incurred all the expenses for the registration, insurance, and road tax. The decision to subsequently, after some time, to keep the car in the family and for it to be used by my family belonged exclusively to my brother, because he, as the owner, has the right to decide on the goods on the assets that he owns. With respect to the reason for purchasing that vehicle, according to what my brother said, for him the value of that vehicle is insignificant, modest, around 10,000 francs at the time of purchase, and it decreased over time, and that amount did not have a significant financial amount on him, and that he did not deem necessary to recover by selling the car, and chose, obviously, to keep the asset in the family. Another reason, he decided to use that good every time when he comes back to Moldova in order not to use car rental services, which are quite expensive for a similar vehicle, and for which he would have had to pay at least 50 euros per day for a similar car, and for the duration of his stays in the country, that would be 300 to 500 euros. From what I know, and again from what my father told, in the period between 2012 and 2019, he visited regularly the Republic of Moldova and had at least 3-4 visits per year, a trend that he kept in the subsequent years too, to this date. Also, out of own initiative and at his request, I helped my parents for various occasions to visit relatives, to go to medical checkups, to get to treatment places, for some household needs. And about the purchase of a Mercedes car, for that property, he paid the amount of 200,000 lei from money that he brought into the country over time when he was coming back to Moldova. He purchased the car in order to use it for personal purposes, but also for the purposes mentioned before. Later, my brother had other opportunities, including business opportunities, in the European country where he is located currently. For that reason, he gave up on the idea of having a business in Moldova, and he decided to give that car to be used, to offer that car to my family, to be used by my family and our relatives. According to my brother, this car does not have a high economic value, and it did not negatively impact his financial situation, given the work that he has and the income that he earns. The aforementioned was confirmed by my brother by means of a statement of own responsibility provided to the Commission when I requested. Also, my brother gave consent for me to share with the Commission his contact data, and because of his busy schedule, given managing his business, at the request of the Commission, he provided detailed data about his activity on the territory of that European country, about his financial resources, purchase of movable and immovable goods on the territory of Moldova. He agreed to provide that information and confirmation documents within the boundaries of what was possible at that time in order to ensure the transparency, fairness, and objectivity of the evaluation process. Nevertheless, the panel, in an inexplicable way for me, did not take into account his statements and all of the documents that were provided and ignored them entirely, assigning it assigning me as an owner of a Mercedes car with no reason, only based on some unjustified suppositions, in my opinion. Thank you. I understand. I just want to make some clarifications because we are also interested in some aspects that are not very clear from the written communication. You said, and you confirmed that now, your brother was visiting Moldova 3-4 times a year, at least 3-4 times a year. And how long was he staying here? Around a week. Maybe a bit longer, maybe 10 days. And he was always driving, obviously. So you and your wife, between August 17th and 22nd and 9th of March 2022, did not have a car of your own, right? Once again, the period 17th August 2016, 9th of March 2022. No. And when he was coming, he was using the car. And what were you doing? How you were using public transportation? I understand. Can you explain how, which is not clear, your brother had one insurance, the first one, on the 16th of September 2016 for the year 2016 to 2017. Yes, that is true. The next insurance in his name was only in October 2024. Yes, that is true. Why? If he was coming every year, why didn't he get an insurance for every year? First of all, we are talking about the moment of a transaction, 2016, and the person who purchased the vehicle, who is my brother, that fact is confirmed by his declarations, by the declarations of the seller, who doesn't even know me and who is ready to come before the commission and tell in detail how he sold that asset. And that person remembers exactly what was happening in 2016? I provided to the commission. I saw after the hearing notice, within the limits of what he remember. We often ask subjects and they say that they forget what happened 3 years ago. That's why I'm asking, does that person remember in so many details? The contact details of that person are provided. You can contact her and contact him, and that person said that they were ready to come before the commission. What mattered for me is the moment of transaction and who purchased it. I never denied that I used the car later on. Mr. Mătăsaru, you are a prosecutor. Yes. If you led a criminal investigation in a case where special confiscation or extended confiscation would be applied, wouldn't you have doubts if you saw a similar situation about beneficial ownership? Let's put it simple like that. I mentioned, and I state it again, I have never hidden that I used that car with my brother's consent. We're not talking about that. The question is, did you buy it or did he buy it? I mean, was it his money or your money? Of course it was his money. Why would he buy a vehicle if he's not living here and comes so seldom? Esteemed members, I provided the Commission with a series of evidence, documents, statements that we have to look at in their entirety. The seller, the buyer, all the initial documents that my brother drafted. He incurred all the expenses. The first insurances, the main insured person was him, and it shows his intention to purchase and to use, not exclusively, but to the largest extent, he was the one who was meant to use that item. His intent was continued by the continuity by a number of a series of the other events, purchase of goods, of real estate, his intent to come back to the country. It is confirmed by the person of Swiss origin who has no reason to make false statements, who said that, yes, I supported him and he was going to come back to Moldova for business and for purchase of a car. Because that person is like a parent to him. He knows details. This person, in my opinion, had no reason. Again, we're talking about the essential moment, who and when purchased. Yes, but let's move on, because you insist that your brother purchased it. Every time he came, he used it. And that's your argument. How much would have car rental cost? That it was not economically feasible. And my question is very simple. Yes, we have an insurance for 2016, partially for 2017. Not health insurance, car insurance, yes. The next insurance was issued only on 3rd of October 2024. The question is why? Why in the period between 2016, 2017, let's be correct, until 2024, he never got any insurance? Subsequently, all insurances were obtained by me, but not only in my name. On an unlimited number of people who can use that asset. This is an important aspect. Why didn't I do it in the first year? Because that item did not belong to me. I did not own it. Only subsequently, after his final decision to go back to the European country and his decision to leave the car in the family, of course, with his permission, I also mentioned to the Commission from the first round, he issued a power of attorney in my name to pay taxes to represent him in relation to that asset. So the essential moment is the year of 2016, not later on. Does your brother have a car in the country where he lives? He's using a car. I don't know if he owns it or not, but he's using a car in his work. I don't know. I saw that the Commission asked for more information, and he, within the boundaries of possibility and within the limits of the time that he had available, he tried to, even though he was not very happy, because he has quite a busy schedule. But does he have a Moldovan driving license or the European country? Initially, he got a driving license in Moldova, but subsequently, or at this moment, he's at an advanced stage of obtaining citizenship, and what share of documents are documents from the country where he lives. Initially, for a long time, the documents were Moldovan and Romanian. I understand.
Eu vă traduc rapid. If you have any questions for public session, if not, we can move to the closed session.
Yeah, I think it's probably best if we move into the closed session. I think there are follow-up questions on almost everything, and it was the subject that requested a closed session for the protection of the privacy of close family members and close persons. So at this point, I suggest we move into the closed hearing.
Unless the subject wants to say anything at this moment in public session, if he wants to, is it okay? Domnule Mătăsaru, trecem.
Let's move to the closed session, Mr. Mătăsaru. If you have any clarification now, you could say that. Anyway, at the end, in a public hearing, you'll have a possibility to intervene. If you want to say now something in the open part, before we move to the closed session, please. Esteemed panel, I want to make one clarification about the arguments that the Commission mentioned in the paragraph 74, that was also about this topic, the mentioned car, in the annex to the hearing notice. All the arguments are typical both for an owner and a person who possesses or uses a car, and those individually, without the existence of other relevant evidence, cannot certainly point towards the beneficial owner of the vehicle. And in this regard, I submitted a practice that was constant for the Vetting and Pre-Vetting Commission, with specific decisions, number of decisions, persons, dates, where similar matters were addressed. Registration of vehicles in the name of close relatives, parents, brothers-in-law, parents-in-law. I don't think I have to state that in more detail, because I did all of that in writing, and the Commission has all of that available.
All right, I think at this point, then, we'll move into the closed session. Back in open session, public session, Mr. Mătăsaru, the floor is yours to make a final statement.
Mulțumesc, domnule președinte.
Thank you, Chairperson, esteemed members of the Commission. Thank you for giving me the floor for some closing remarks. To conclude, I would like to say that before the beginning of the external evaluation of prosecutors, I was entirely aware of the fact that it was going to be a complex, difficult process that will envisage me and my family directly and my close relatives as well. Nevertheless, knowing the lifestyle that my family has and my close relatives, parents, brothers, brothers-in-law, and giving also the fact that in my more than 20 years of activity, I always follow principles of impartiality, transparency, and integrity. I have never had the reason not to accept to go through this evaluation process. Even though certain doubts about my financial integrity were found, I believe that they are not directly related to me, but they relate to the financial aid I received from parents, my wife's parents, my brother, help that resulted from their work done in country and abroad, from their honest work over many years in a way that does not contradict the law. Even though some of these income come from informal employment, that is because of economic and social reality of Moldova, and that cannot be ignored by anyone. Furthermore, the deficiencies in the legal framework in some specific situations cannot be imputed to me or to my family members or close relatives. In this context, the economic support of the country by diaspora and the existence of this unfortunate situation for our country and the sacrifice made by parents who left children, household, jobs, their position in society behind in order to ensure a decent living and a safer future for their children cannot be denied by anyone. Them obtaining unofficial income or that cannot be proved to the extent that the Commission requires cannot be imputed to me as a subject of evaluation because that was the national, social, economic context at that time. One important aspect is the fact that during the evaluation, the Commission did not find any doubt about my professional activity and the ethical aspects, which proves that I fulfilled my duties with integrity, with dignity and dedication, which was confirmed by the multiple incentives provided to me by the Superior Council of Prosecutors. I would also like to state that during the entire evaluation process, I did all the due diligence to provide the Commission all documents, statements of known responsibility, pictures, confirming documents that were possible to obtain in order to events that took place and create the objective and real picture of the condition at the time. I understand that the evaluation process can be perfect, but at the same time I count on an objective evaluation based on the analysis of evidence provided by me and evidence collected by the Commission. In the end, I would like to thank my family members, my wife, my children, who supported me unconditionally for the entire duration of the evaluation. I'd like to thank my mother, my wife's parents, my brother, who were by my side, despite my brother's busy schedule and older age of the parents. At my request, they stayed in long queues at social authorities, tax authorities, mayoralty to obtain needed documents. They made effort, they invested time to obtain relevant declarations from various people in order to clarify some situations that I provided to the Commission, which considered jointly confirms their financial capacity to provide the declared donations to my family. Also, I'd like to thank the colleagues who are now going through the evaluation. I wish all of you good luck, the best of luck. Thank you.
Thank you, Mr. Mătăsaru. We thank you for your participation throughout the evaluation process and at the hearing today. The panel will now deliberate on these matters and the hearing is closed.